This is a paper that I wrote for a conference that dealt with the history and the evolution of patent law. And at one sense, when you're dealing with these issues, it's important to recognize in this case, perhaps as not in the other, there is a huge practical and current debate that is going on, which relates to the status of what do we think about a patent right. To give you an idea of just how important this question is, if you decide that patents are property rights like other forms of property rights, they becomes much more difficult for you to dislodge them in any way, shape, or form. It turns out that when you're dealing with the protection of property rights, Article 3 courts are generally going to be provided. If you're dealing with something less than property rights, then what took place with respect to the American Invents Act and inter partes review, which allows a defendant in a district court to bring the thing on issues of validity before a patent tribunal in which the judges are appointed by the head of the PTAB, not on a rotation basis, but on an ad hoc basis to decide these cases without any of the standard protections, including discovery and Seventh Amendment protections that you would get into court. It also turns out that the nature of the remedies that you're going to get is going to be somewhat weaker. There is, at least within the traditional literature, a notion that an exclusive right would give you a presumptive right to an injunction. But then it turns out that if you go into these situations, the eBay rule becomes much more important. So trying to figure out this subject is no very easy question because it turns out that what you have to do is to develop a pretty sophisticated theory to figure out how it is that the patent clause ties into a system which has an amalgamation of federal and state rights. As an initial assumption, I think virtually everybody agrees that the patent power is just that, a power, no more, no less, and that the state itself could decide never to execute the system of making patent grants to any individual. There would be no constitutional violation. On the other hand, as is perfectly evident when you start to look at the Patent Act of 1790, is that from the very beginning, people started to give patents. They gave them with the explicit term grant. The word actually makes a difference. If you assume that a patent is just some kind of nebulous protection that the state is giving against other individuals to use, then what happens is the patent does not necessarily carry with it the right to license it, to sell it to some other third person. It only may give you at best some kind of a remedy if somebody else decides to intervene, but the entire commercial market, which depends upon sale and licensing, particularly licensing, would be something that would not be there. So the question then is, how do you get this? And here there is an interesting discussion about the whole natural law status of property rights. And for those of you who are not familiar with this particular body of literature, it starts off in Roman law. The first paragraph of Gaius introduces it, and essentially we're told that these kinds of rights are created as a matter of the rights of nature. The definition and the explication of which is not all that clear. But the clear implication was, at least if you look at the Roman sources, is that these kinds of natural rights would have at least three characteristics. They would tend to be universal across different cultures. They would tend to endure over time, and they would tend to meet some kind of independent standard of rationality. At the time, that was called human flourishing. Today, the term that would be preferred would be some kind of instrumentalist or utilitarian kind of justification. If you look at the way in which patents are done, it is quite clear that the common law rights associated with use and disposition to which I referred are in fact regarded as common law rights. They are not rights that are created or granted under the federal constitution. What is granted under the federal constitution turns out to be the exclusive right to sell these things. And exclusivity under these circumstances has a huge amount of pop, because if somebody else is not in a position that they can use the particular thing, then you can get a price well above marginal cost when you sell this particular patent. Everybody understands why you do this, at least in the American context. If you wish people to invent something and they could put it out there without patent protection, other people could produce it at lower cost than they could. And so the inventor would be the last person to profit from the market. What the monopoly or the exclusive right provision does is give you a chance to earn an honest return on that particular situation. These rights, however, are limited in time under the Constitution. And so it's exactly in that particular fashion that the early Patents Act were done. There was no effort to kind of give a sham definition. So we give you a million-year patent and so forth. They tended to be for 14-year terms, renewable and so forth. So if you then start looking at this situation, It seems to me that the grant interpretation, which was found, I think, is clear from the statute, the constitutional text, was also very much influenced in the construction of the 1790 Patent Act. And I'm just going to mention a couple of things about it because I think it starts to tell you something about textualism and interpretation. The first point is, as Nick Perillo said, I think in his presentation, that there are many times when you see an early interpretation that you're not troubled by kinds of difficulties. This is not the Alien and Sedition Act, which was immediately given to a buzzsaw. This was a fairly detailed statute in which there was perfect unanimity. It's also clear that this statute contains a fairly extensive delegation. In that case, the three major cabinet secretaries. Today, the delegations take place in an obviously different fashion. It's also clear that you don't give a patent away for nothing. What happens is you have to show that you're creating some kind of science or useful art. This, as Adam Mosso showed very nicely, is very much in contrast with the English tradition, under which you have a situation in which patents could be given by the Crown in exchange for a price paid to the Crown, which would allow you essentially to have a monopoly over importation of a good, with the usual negative consequences of a monopoly, higher prices and lower sales. But in this case, it's very different because if you make the thing, without it, you get no sales and no profits. With it, you get monopoly profits. And then the exclusivity right is essentially compromised down the road so that it can be used freely by everybody else. This pattern is not only used in connection with patents, it was also used in connection with grants to make bridges and so forth, this bipartite citizenship. So if you go through all of this stuff and look at the particular procedures, what happens is the originalist doctrine gives you the skeleton of what have, but you have to understand the things that are going to be left necessarily to implication. There are going to be certain questions about scope having to do with, for example, on the doctrine of equivalence that are going to be as a matter of judicial interpretation. The question of whether you get an injunction in every case on the exclusive right is again going to be a presumption, yes, but it's going to be subject to laches and other kinds of affirmative defenses. And so what you do is you sort of develop a kind of what I would call contextual originalism, is you start looking at the particular text, but the way in which to understand how it actually fleshes itself out, you take the background principles of interpretation that have existed from the beginning of time, i.e. from Roman law through the English law. Those are called the general part in sort of traditional continental jurisprudence, and graft them onto the basic system. And so that what happens is originalism, as they understand it, is not simply a question of finding the original public meaning of standard terms. It's also finding a way to incorporate the standard background conditions. This is an important development. It applies not only in this particular case, but you can think of doctrine after doctrine where some implication from standard common law doctrines are going to be carried over. There's no police power in the Constitution. There's no immunity doctrine in the Constitution. There's no unconstitutional conditions doctrine in the Constitution. And it's only, I think, if you use this particular method of using the analogies from public to private law that the system gains its internal coherence. I see that my time is up. Thank you for not reminding me, Maimon. Over to you, Christina.